Thanks for joining us. Welcome everyone to today's webinar, Countdown to the California Consumer Privacy Act, What You Need to Know Now. I'd like to introduce today's presenters. Joining us is Scott Giordano, Vice President of Data Protection at Sperian. Scott's a highly regarded data privacy attorney with over 20 years of experience. Also joining us is Katie Stevens, Director of Security and Privacy at Protiviti. Katie specializes in operationalizing GDPR and CCPA across global operations. Welcome, Scott and Katie. Please take it away.
Wonderful. Thank you, Abby. I want to welcome everyone to the webcast today, and I am delighted to have my friend and colleague, Katie, with us. Together, we're going to tell you everything you need to know about CCPA right now. So it doesn't quite set the bar too high, but here we go. So a couple things. Not surprisingly, I'd love to share things that I think you need to leave with, if nothing else. This statute is not going away. It's not going to be defanged by the lobbyists. The federal government is not going to ride into the rescue, regardless of what you might have heard. So what we've got is what we've got. There are some amendments floating around out there. I'll talk about those in a little bit. But by and large, what we've got is what we've got. And so this is what we're going to work with. CCPA borrows many of the elements of GDPR, but there's some subtle differences, especially with respect to sales, and I'm using air quotes here that you can't see, sales of personal data. So we'll talk about that. Also, understanding where personal information lies in your business and to whom you're selling it and with whom you're sharing it, especially third parties and cloud service providers. That's key. We'll talk about that as well. So let's get started here. Also want to encourage everyone to send in questions. I know many of you sent in questions already. We will get to those towards the end. There was a lot, so obviously this is a hot topic. So let's talk about some of the essentials of this legislation. This is effective January 1st of 2020, but there is a 12-month look back. And I'm going to hammer that idea a couple times here because it's important. Essentially, someone can send you a data subject access request, or whatever we're going to call it, on the 1st of next year and ask you for what personal information you've gathered about them in the previous 12 months, which means that you need to be looking at that now and get an idea of what you are collecting. And the list is long of what qualifies as personal information. I'll dig into that. Also, what's important is that this applies to all businesses that use or collect this personal information, not just those in California. This is one of the larger misunderstandings I run into. And really, any company in the country is subject to this if they are collecting personal data of California residents. And so this doesn't indeed apply to consumers. It's a rough equivalent to data subjects, those of you that are GDPR veterans by now. So it even applies to employees, in some cases to patients and students. Again, I'll touch upon that later. So there's a lot of rights here, but as a practical matter, there's three big ones that you really want to know. One is to be informed about the personal data that's being collected. Second is a right to prevent the personal information from being sold to third parties. And then a right to go to the third parties and tell them, don't use the data you already have. And that's a particularly thorny problem. We'll talk about that too. California Attorney General can enforce this. There's a very limited private right of action if there's a data breach. I won't spend too much about that. Just suffice to say that the California AG will come down on you for violation. So let's go to the next slide. So who's protected? I mentioned earlier, consumers are protected. However, it also protects devices and households. And this is something that's not mentioned in GDPR. So this is an area where it is there's a distinction. So devices, basically things you would presume are internet connected, like your cell phone or your router or just about anything. If you're familiar with Internet of Things, anything that connects to the internet, that's a device. Households also are in scope here. However, they don't define it for some strange reason. So think about cable TV use, for example, or power use or water use. Likely those are things that are indicative of household personal information. Let's go to the next slide and talk about businesses subject to the Act. This is a challenge, and here's why. If you're a business and you conduct business in California and you meet any one of these three thresholds, you are in scope for the law. So that sounds simple. The problem is that we don't know exactly what qualifies as doing business. And I'll give you an example. You have revenues greater than 25 million, or you're involved in selling personal data of more than 50,000 consumers, households, or devices, or you get more than half your revenue from selling consumers' personal information. Is that confined to California, or is that US-wide, or something else? The short answer is we don't know. It could be confined to California. It could be global, for that matter. So we don't know. So it's fairly easy to be caught up in the scope of this and not realize it. Also, truly, this is global application. There's no limit put in the law saying that it only applies to companies within the 50 US states. So if you're watching this from another country, this potentially could apply to you as well if you are collecting data of California residents. Let's go to the next slide. So what do you need to know right now? One is the disclosure piece of this. Disclosure covers the 12-month period preceding the business's receipt of a verifiable consumer request. So if you're familiar with data subject access requests, same exact concept that was more or less copied from GDPR. Shall be made in writing. Yep, that makes sense. You will have to put it in a form, electronic form, a written form, what have you, but it can't be verbal. And it has to be in a reasonably usable format, meaning a Word or an Excel or a PDF or something like that. That, again, was copied right out of GDPR. So you can see how a lot of this was heavily influenced by GDPR. There's an entire project going on at Microsoft and other companies to create a portable format for all kinds of documents. But right now, what we've got is Word and Excel and PDF and so forth. Let's go to the next slide. So what is personal information? This is really where the war is won or lost, folks. And the legislature didn't make this easy. So personal information, information that identifies, describes, relates to a consumer or household directly or indirectly. That makes sense. That's a fairly generic definition, very GDPR-like. But then they add this additional one, which really doesn't help very much. It almost repeats that word for word. And the idea, and I'm referring to the paragraph here in blue, this was added to by an amendment to the last year. And essentially it's saying that all the things that follow are personal data unless they're not personal data. I mean, they can't be linked to someone. So it was utterly unnecessary. Not sure why they did it, but they did it. So just so you know. If we go to the next slide, I'll show you some of the examples here. Some are going to make sense. Some I think are a little unusual, we'll say. So for example, unique personal identifiers, online identifiers like IP addresses, etc. These are all things that you would expect would be personal data. Social security numbers, driver's license numbers, passports. No surprise here, this is pre-century stuff, but it gets better. If you go to the next slide, they add all kinds of things. So they're going to add here physical characteristics, your education, your employment history. So it's really adding another layer of things above and beyond things you would presume would be personal data. And you say, Scott, can it get any better? And the answer is, well, yes, it can. If you go to the next slide, it indeed does get better. So protected classifications, meaning protected classes. So Title VII civil rights, that's what they mean by protected classes. And it gets even better than that. Personal property, products, or services purchased, obtained, or considered. So imagine that you're on a commercial website like eBay or Amazon or whatever. Things that you just consider, things that you look at. Now that's in scope. Your purchasing histories or your tendencies. I don't know how you get a tendency, but that's in scope now, okay? If you go down to section F, you're going to see it says browsing history, search history, interactions with websites, applications, or advertisements. That's a full-time job in and of itself, finding that information. That's now all in scope. And you say, Scott, can this get any better? And the answer is yes, absolutely. This is the California legislature we're talking about. So if you go to the next slide, it does indeed get even better. So audio, electronic, thermal, olfactory, so how you smell. That now is personal information. So I know you feel like the legislature has really gone above and beyond, but they've added section K here, which is inferences drawn about this. So think about inferences that are drawn. That alone is something that even GDPR really doesn't touch on directly. It does so indirectly as far as profiles. This touches on it directly. So not only is the information you collect, but information that you combine and you create additional information, that's personal data. So it really creates a list of things that are so long. The question really is, what's not personal data at this point? Abby, I'm going to do a full stop there. Are there any questions or comments before we go on?
Yes, quite a few questions. Try to get through a few of these. Is someone required to have a do not sell my personal information link on their homepage if they're not actually selling personal information?
you have to indicate that you're not selling personal information. So there doesn't have to be a link if you're not selling it, but you have to indicate you're not selling it. So that's how you would resolve that.
Okay, great. Is there any impact from the California Shine the Light regulation on CCPA?
There is not an impact. I will actually cover that in the Q&A section because that was emailed in earlier. So yes, that will definitely cover that. But the short answer is not directly no.
Okay, and how does this apply to a person who was not living in California when the data was collected?
If the data was collected from someone who's not in California, then it's not in scope until that person becomes a California resident. So here the danger, of course, is that when people move to California and you're taking data that was previously not in scope and now you're marrying it up with data that is in scope, it's hard to separate the two. It's the same problem from GDPR. If you have someone who's a student, maybe from the EU, you establish that relationship there, then they show up here in the US to go to college. Now you've got data that's covered by GDPR and data that's not. Are you going to keep those two separate? It's very difficult. So this is the same challenge.
Okay, we'll take one more question for now.
Okay.
Is the 25 million in California sales our total company revenue?
We don't know. That's the problem. We just don't know. We're waiting for the AG's office to issue some guidelines. Right now, it's an open question. So it's probably safer to presume that it's any revenue globally rather than just that's confined to California. Okay, let's go to the next slide. So what you need to know now, data inventory. One of your to-dos is going to be, if you're not already working on a data inventory, to get one going because you have to be ready by January 1st to be able to start sharing the data information you're collecting. What you're seeing here is a real data inventory I worked on when I was with Robert Half. I've changed the name to protect the innocent, but this is a piece of a much larger data inventory. It's a big process, and it's an important process to go through. It's something that every organization is going to have to do eventually just because of all the new laws that are coming online. So the net of it is that if you see in the red box here, these are the items that are personal information for these two programs, these two applications or apps as we call them. For the MDM tool, your IMSI, your IMEI number, device ID, electronic serial number, these are pieces of personal information. They need to be accounted for, and if they qualify as personal information based upon California residency, then it's something that you would be sharing with that resident. Same thing for the DLP tool. Again, the equipment identifier, if that's linkable to someone, user ID, your AD credentials, etc. So you can see you really go down the rabbit hole when you start doing a data inventory, and it's an important process. So it's something that if you haven't started, highly recommend that you get going because the clock is ticking essentially. We go to the next slide. Third parties. This is a tough nut, and it's a tough nut because of the nature of who qualifies as a third party. So you've got three rights as a consumer. You've got the right to direct a business that shares information with third parties not to sell the consumer's information, okay? And sell has a very broad definition. I'll touch upon that in a minute. Business that does sell the information to third parties has to give you, the consumer, an opportunity to opt out. And this information that they're selling, not only do you have the right to opt out, but you have the right to go to the third party and tell them that if you already have my personal information, don't sell it. So really, there's three different rights here. The right to tell someone, to tell a business, hey, don't sell my personal information. Right to direct the first party, if you will, or the second party, I guess it would be the collector of the information. If you're selling it to third parties, don't sell it. I'm going to opt out. And that's where it has to be on your website. But then the third parties themselves, even third parties you don't have anything to do with, you have to be able to tell them not to use any personal information that they've collected. And that's going to be a real challenge because a lot of these third parties, they're purely commercial in the sense that they serve as other companies. They don't have any direct connections with the public. Now they're going to have to. Otherwise, they're going to have to work through their customers, they're essentially the second party, to make sure that they're collecting all the information they need to know to get rid of whatever information is requested to be deleted. And here's the challenge too, is that you have service providers and you have third parties. Service provider is what you would probably expect. It's a cloud service provider. Maybe they're providing storage or some other function versus a third party that's using personal data for its own purposes. This is something that you really have to go through all your contracts and sort out who's a service provider and who's a third party. Because If you don't prove that you're a service provider, you're essentially a third party, and it's not easy. You have to go through and determine all the things that you're doing. Is there a business purpose for the information that's being shared, etc.? So that's something that, again, if you haven't worked on, you really want to get your legal team involved, get them to go through all the contracts that incorporate personal information and determine who's a third party, who's a service provider, and start making all the changes that are necessary. It's the same thing we went through with GDPR, went through all kinds of agreements and had to change everything, had to sign data protection addenda to address all the issues of GDPR. Likely you'll have the same process here, and it's something, again, that you really should be started now. Also want to let you know that this idea of selling personal information, basically just about anything is a sale. So if you give personal information to a third party and they're going to use it for their own purposes, effectively it's a sale. So keep that in mind. It's very easy to quote unquote sell personal information and not really realize you're being caught up by this. We go to the next slide. What you need to know now, your privacy policy. And again, when we say policy, we really mean the privacy notice. There's 4 big areas that you have to address when you update your privacy policy that's going to be on your website. Areas in blue that I'll show you on the next slide really are things that you can pull directly from your data inventory. But for here, consumer rights, we mentioned earlier about having to disclose information, no discrimination, no sale of personal data or transfer. These are things that you have to list now on your website, that these are rights that the consumers have. And then for our next slide, you'll see specific things that you have to go list. Categories of personal information you've collected, the categories of the sources of the personal information. And this is similar to GDPR, where you have to determine from whom you obtain the data and then share that, even if it's broadly classified as a service provider, for example, a cloud service provider or someone like that. But it's got to be a category of the sources that you receive the data from, the business or the commercial purpose. So why do you have the data? And then the third parties with whom you're sharing the information. So this is something that all of which can be obtained from your data inventory, presuming that you've done it thoroughly enough. This is going to really force you, though, to go to great lengths to find out exactly where the information is coming from and where it's going. And then if we go to the next slide, list of categories of personal information that it has sold or disclosed for business purposes in the last 12 months. If no such sale has taken place, you can note that instead. So again, I mentioned that earlier. Same thing here, you can note that instead. And then one or more abilities to contact the second party, the collector of the information. I'm going to do a full stop there. Are any questions before I hand over to Katie? Or Katie, if you have any comments, I'd love to hear them as well.
No, Scott, actually, everything you covered, I will also provide a quick summary of the requirements too. I think, one of the key challenges, as Scott pointed out, is companies that start CCPA compliance efforts quickly recognize that the personal definition is so broad now that historically when we looked at personal information as, the PII, what we called it for financial services, now personal information is much broader. So when I speak a little bit more about the compliance efforts and how to tackle CCPA compliance, I think that continues to be a key challenge for organizations, is to figure out what is personal information and where do I have it.
Okay, well, in that case, then how about I hand over to you and you can give them some more in-depth about this.
Sounds good. And we can dive into the next slide that really highlights what Scott already mentioned, what are the key requirements. And if you think about, GDPR, CCPA is very light compared to GDPR. We know that there's still amendments that are being evaluated, but really there's 3 buckets of requirements that we think about when we think about CCPA compliance. At the top left there, you see the privacy governance. So your organizations do need to figure out who owns privacy within our organization. And if you don't have a privacy team, someone needs to be identified to own privacy in order for your compliance efforts to be successful. Privacy policies and procedures, again, many organizations already have a privacy policy, may already have some procedures. So you're not going to be starting from nothing, right? You should evaluate and understand what do we already have in place and how do those privacy policies need to be modified to meet the new requirements. Number 3 here, privacy awareness and training. So, CCPA goes into effect January 1st, 2020. So prior to that date, there needs to be an effort to train your employees and provide privacy awareness and training. And that is one of the requirements within CCPA. The second bucket we get into is the lower left corner here is records management. And as Scott already pointed out, record of processing is this data inventory effort that every organization needs to go through. If you're not considering to do a data inventory, most likely your compliance efforts will not be successful, because that record of personal information and where those records are kept is key success to not only responding to consumer privacy requests, but also to really understand the risk of personal data that you have within your organization. And the example I always use here, if you think about a system that has, Katie Stevens as just a single name or a user ID, that's personal information, versus a system that may have my name, social security number, my financial records, and my healthcare records, the risk that is carried with those two systems is different. So the first example is going to be much lower risk of information versus the second example, where you have a lot more sensitive information about a consumer. Number 5, third-party management. Again, you have to keep track of where the data is going, who are the third parties that you're dealing with, and not only downstream who you're sharing information with, but also where the information is coming from. Because if you're purchasing information from a third party, or if you are obtaining information from a third party, there's still a requirement to comply, to include that data within compliance. Just because you're not collecting information directly from the consumer doesn't mean that those records don't need to be compliant. And additionally to that, third-party management becomes all about managing your contracts and managing the validation of compliance for those third-party organizations. And on the right side here, we have privacy obligations. Again, Scott talked about privacy notifications and disclosures, the key requirement. Consent management, if you're collecting information about children, you have to manage consent. Additionally, if you are selling the data and you're allowing consumers to opt in and opt out, that becomes a very significant and resource-extensive process to keep track of who opted out, who did not opt out, whose data can we include in the sale, and whose data do we need to exclude from the sale. And then number 8, the last section, this is really the majority of CCPA requirements, is to be able to comply and fulfill consumer privacy rights requests. So after January 1st, 2020, consumers will be able to come to you and say, give me all the personal data you have on me, which is right of access. They could also ask you to export their personal information and give it to them in a machine-readable file so they can take that data and take it to another provider. I think the right to be forgotten is one of the key challenges, right? In the United States here, companies are not used to really deleting data. I think historically we always said, oh, the more data we have, the better. Well, that's no longer the case, because consumers can now come to your organization and request this right to be forgotten, which will require you to delete some of their data. And right of equal service, I think that really complements this requirement of sale. If you are selling data and somebody wanted to opt out from sale, you have to make sure that the services you provide to the individual are not any lower quality, and that right of equal service is very important as well. So we can go to the next slide. I think before we get into compliance efforts, and Scott really covered this in good detail, so I will not spend too much time on this, but if you think about compliance efforts, you do need to understand who are the key players within your compliance efforts, right? We have your consumers. So you need to understand, what type of consumers do I deal with? Do I deal with customers? Do I deal with vendors? Do I deal with, what personal information, or what type of individuals do I collect personal information about? Now, if you're a business, right there in the middle, business is defined as an organization that actually determines what to do with the collection and processing of data. If you're a business, then you have to comply with all of the requirements of CCPA. Now, if you're a service provider, on the right side of this slide, as Scott pointed out, service providers' obligations are much more limited. However, the contracts need to be very clear that state and prohibit sharing and retaining and disclosing personal information. So if you're a service provider, you still need to fulfill the right to be forgotten. That would come from the business with whom you enter into agreements. But you may not need to actually respond to any other requests, right? The right to be forgotten is definitely in scope. And if you are a third party who is not a service provider, then there's a lot more requirements that are in scope. In addition to the opt-out from sale, you do have to consider if you're obtaining the data from the business and you're using that personal information for the purpose of your business outside of the agreement with the business, then actually you may become the business and still have to comply with all requirements. So we can go to the next slide. So really most clients that come to me with their questions about compliance, they first want to understand, well, what does this mean? Where do we need to get started? So key considerations is you need to think about identification of personal information. What do I have? Where does it reside? And once you capture the list of personal information stores and processes within your organization, then you also need to assess the risk of that information. Again, in my earlier example, some of the processing may carry lower risk versus other processing that may carry higher risk. So what we recommend clients is once you understand what you have and you prioritize it based on risk to the individual, it is the best idea to focus on higher risk items first and then, work down through your risk prioritization criteria because you want to secure and address those higher risk items first. And then, execution, right? Who's going to be the owner of data privacy? Do we engage all of the right business stakeholders, right? All those questions in the execution phase is when you start really designing your privacy program. And once you finish with the effort, unfortunately, you do have to continue focusing on privacy after January 1st, 2020. You do need to monitor compliance, respond to complaints. Audit teams have a big role in this monitoring process, right? Audit teams can come in after January 1st, 2020 and really audit the process. And then also reporting to the board of directors, right? If you are spending the investment to comply with CCPA, the organization and executive management will want to know how do we maintain and monitor our compliance going forward. So I'll pause there just to see if we have any questions. I know we are about halfway through the session. I still have a couple slides to cover to tell you more about how to implement your compliance efforts, but I think this could be a good way to pause and see if there are questions.
Sure, we have lots and lots of questions for you guys. Who will oversee or audit, I guess I should rephrase, who should oversee or audit the CCPA compliance?
Right, and I'll share my experience, and Scott, feel free to jump in. So CCPA ownership of the program usually will live within some sort of a compliance team or a team that's independent from business and technology. The audit of CCPA compliance should live with the internal audit team.
Yeah, that's exactly right. Internal audit really needs to be the ones to go take this on. And in fact, that's how it worked with GDPR. So the same would be true here.
Okay, great. How can a customer find out all the companies that their data was sold to?
Oh, that's a great question. I don't have a very efficient answer to that. As a consumer, this request may be triggered by something that comes in the mail, by certain information that companies may have about you. But some consumers may actually start fishing for information and start, submitting requests across all sorts of organizations. So I don't really have a good way to tell you how to understand all companies, but I think there is definitely ways on how consumers will begin fishing for that information.
Yeah, I agree. There's not one place you can go to get everything. I think as a practical matter, you're going to find that a handful of companies probably have the bulk of the information. So I would think about those handful of companies, and we all know who they are, that are most likely to have that, and ask them first, and then over time you'll be able to determine who else likely has it as well.
And another important point is, so what is important with CCPA, right, it gives consumers the right of private action. So if there's a breach in the news, as a consumer, I will automatically want to know, was my data impacted? And if so, is there a class action suit that will be organized that I can participate to make sure that I get some sort of value from that negative impact of my data being breached with a certain organization?
Okay, perfect. They did submit a secondary piece for that question too, stating if the company sold their data, for instance, to another company, and then in turn that company sold it to another one. So I think you guys did a good job of answering that overall.
Yeah, I mean, I think you can quickly see how this chain reaction, right, can really allow consumers to see how data is traced, because whenever the sale happens and you opt out of sale, and then companies will be disclosing who they're selling information to. So even from the first request from a single organization relationship, a consumer should be able to get quite a bit of information how far down the chain their information is being shared with or disclosed to other organizations.
Okay, we'll take one more question for now. If a consumer requests that they remove all of their personal data, should they consider computer backup tapes as well?
Excellent question. And I will tell you that this has been the topic for the last 2 years that's been challenging with GDPR and now with CCPA. So if your backup process works in a way that as you refresh your backups, if you delete the production record and your next cycle you overlay that copy with a new copy, technically that record should be gone. So I think that the expectation is you would not be going out and restoring data just to delete data. If you implement the right process operationally, you should be able to overlay the new production copy where data was deleted and therefore get rid of that backup copy within your time schedules.
Yes, I agree, Kay. That's largely the correct analysis, because otherwise it would create absurdities where organizations would have to be restoring things just for the purpose of deleting information. And really, a backup tape is there for a disaster. It's not really something that you're going to be using day to day. So your analysis is absolutely spot on.
Yeah, and I always tell my clients too, this right to be forgotten is scary initially, but if you think about it, if consumers start asking us to delete all this data, we're not going to have a business to run. So what you have to consider is, to an extent, this consumer is an active customer, and to an extent that you have retention requirements. So if you, for example, in financial services industry, you can't just go and delete data per consumer request. So as you create your inventory and develop your process to respond to consumer requests, you do have to take into account your retention requirements. So having one well and clearly defined retention requirements, and then applying those retention requirements across your information technology environment becomes very important, because those records and the data within the retention schedules will not need to be deleted. You need to have that record as per your regulatory requirements.
Okay, awesome. We have about 15 or 20 more questions in queue. If you want to take one or two more, we can save them for the end.
So let me just maybe step through our approach and some more details about compliance efforts. And if I don't answer those 10, 15 questions, we'll definitely have the 15 minutes at the end.
Perfect. Thank you.
So if you have not started your CCPA efforts, the approach that we take with our clients is, as you see on this slide, 4 petals, right? Number 1 is discovery and inventory is very, very important. If you don't do this exercise, you are going to miss significant areas that need to comply with CCPA. So number 1, I'll talk more detail on what to do within each petal. So discovery and inventory is very important. Number 2 is the readiness assessment, looking at what data do I have and which role do I play within the CCPA regulation, is understanding what requirements apply to your organization. Do you sell data? If so, there's requirements that will apply. So really doing kind of this gap analysis of what you have versus what you need to have is very important too, because again, I can't stress enough that most organizations already have some sort of privacy controls in place, and you may not need to start from scratch. You may need to just modify, whether it's policies or privacy notifications. So understanding what you have and figuring out what you need to do becomes very important. Number 3, you naturally go into the gap remediation. So most organizations don't have a process in place today to respond to consumer privacy requests. So that's an easy one that if you don't have that, you know that you need to stand up a process by January 1st. Vendor management, and again, upcoming slides will tell you a little bit more examples of what we already know companies don't have, but gap remediation takes time. So if you haven't started, it's very important to start as soon as possible so you have enough time to remediate the gaps that you identify in phase 2. And then compliance monitoring, so that comes usually after the regulation goes into effect, and that's when you do your audit. You may want to actually do an audit before January 1st, right, depending on your timeline. But compliance and monitoring is really an ongoing process. And we can go to the next slide. So I think discovery and inventory is a scary phase for most organizations, because when we think about all of this data we collected, many, many years ago, all the systems that we have, but I want to tell you that it's actually not that complex. Again, we're trying to get to maybe 80% of all data, and when you think about the discovery and inventory, you really need to understand where is the data, well, first, what personal information do I have? And then where does that data come from? What do we do with it to process that data? So is it background checks? Is it kind of more high-risk processing versus perhaps just, storing vendor information or, service provider information? Where is that data going to, right? The transport of data. Where do we store it? And how is it distributed outside of our organization? And then the destruction. So again, if some of you have not done a data inventory exercise, we're happy to share our approach after the meeting, but that is a very important effort. And oh, by the way, when this effort is completed, 80% of your systems will be in scope. And we're not recommending that you address all 80% of your systems. You need to apply a prioritized approach, identify what systems may be higher risk, and work through those first. And, when you get to the lower risk system, as an organization, you may actually accept the risk because the risk of the information housed in those systems could be very low. So then the next phase on the next slide is gap analysis. So I just highlighted some of the key compliance gap that we're seeing when we complete that phase. One, record of processing. Not many organizations have a record of processing. And again, once the record of processing is created, there's really lack of ownership and maintenance process going forward. Consumer privacy requests, that's definitely a known gap. CCPA requires you to respond to consumer requests within 45 days. If you imagine the process, by the time the request comes in, you validate the identity of the consumer. By the time you have to go search all of your systems for that privacy information or that personal information, that 45 days could be a very, very quick turnaround. So having that process well-defined and well-communicated across your organization is going to be critical. Third-party management, again, managing your contracts and understanding the risk associated with sharing personal information. Consent management. Again, consent management is not something that we've done well historically because we never had to do it, but now consent management becomes important for understanding who's opting in, opting out from sale, as well as making sure that you have consent for parental consent for information for minors. And I think all of you probably heard on the news there's a provider, well, the app out there that was recording video of minors without any consent, and they got smacked with a pretty large fine, and I think they're still on the news. So just one example. Privacy notice, Scott talked quite a bit about that. Privacy notice, most likely your privacy notice needs to be updated. And the question you may want to consider there, do you update the privacy notice in general for all states, or do you create a privacy notice just for California? And I always tell clients, please, consider doing an update for all states, because as soon as CCPA goes into effect January, I think we have several other states who are waiting to see what's going to happen, and then they're going to pass another state regulation similar to CCPA. And the last one, data retention practices. So again, that's really a gap that exists in many organizations. Sometimes you have data retention practices and schedules defined but not implemented, but most of the time organizations don't really have a good final and approved list of retention requirements that are carried over to the technology environment. So that's always a key gap that comes out from our assessment. The compliance remediation, right, the roadmap. So here on this slide, I just gave you an example of what remediation efforts look like. And I do want to point out that at the bottom of this slide, you have a responsible party. And I think this clearly highlights that privacy is not a problem of one team, right? Privacy is a challenge that crosses all key functions within the organization: legal, IT, business, data privacy office, internal audit. And again, to address some of the compliance gap I covered on the prior slide, right, you want to do the data inventory first. Then you also want to start taking a look at your consumer privacy request process, because to stand up a process of accepting requests, auditing those requests, and really you need to have a record of the requests and everything that you've done with the request, because if there's a class action or you end up going to court over someone's complaints, right, you need to have all the right evidence in place to prove that you have responded to the individual within 45 days. Third-party contract remediation is usually owned by the legal team, is really going through an assessment, understanding, is this a service provider? If so, do we need to modify contractual agreements and contractual terms? Or is this a third party and maybe we need to understand how we're sharing data with a third party if they're not a service provider? 6 and 7, so the sale, opt-out, and opt-in process. If you do sell data, you need to really design and implement a process of tracking who's opting out. And then additionally, you do need to update your privacy notice, as Scott pointed out, to either state that you do not sell data or provide the option to opt out. So that is a requirement we know must happen. You either need to update, say, we don't sell the data, or you need to implement a process to allow consumers to opt out. And number 8, number 9, usually owned by the privacy team, right? Standing up a program, ongoing compliance program, and then really providing training to all of your employees within your organization. And the last one, data retention and erasure, understanding what data should be erased and what data you need to keep to run the business, because you have a regulatory requirement to keep the data for a number of years. You know, the last work stream right here, you see internal audit advisory support. I usually recommend my clients to engage the audit teams early on in the process, so they have a preview into all of their remediation efforts, so they feel confident, and also provide their feedback into your compliance efforts. And then we can go to the next slide. So ongoing compliance. So what does this mean? And I think whenever my clients ask me, well, what does this mean to be compliant? And I'll tell you, I'll be honest with you, it's not very well defined. But if you think about accountability approach, and that's something we'll learn through GDPR, we do know that in order for this program to be effective and for you to be able to provide evidence and proof of compliance, one, you need to establish controls. Whether it is privacy controls, data security protection controls, you need to establish a formal set of controls that you'll be following. Number 2, you need to assign ownership. Who is going to own fulfilling those controls and making sure that those controls are operational? And then number 3, you do have to capture evidence or be able to produce evidence of compliance. So if you really take the accountability approach, depending on whether it's an investigation from the regulators or investigation for a legal matter, you will be able to prove your compliance efforts and accountability if you take that approach. So Scott, this is really my last slide, so we can take more questions and then go through our final thoughts and final considerations.
That sounds fabulous. Let's do it. Abby, I'll tell you what, let's do this, Katie. Let's summarize, and then let's jump to the questions that got emailed in. I want to make sure that those folks get in line here. So let me summarize, and please, Katie, chime in too. How to get there from here. Create your data inventory. We mentioned that a couple times. What I do want to also add, though, is that when you start your data inventory process, you're going to find things you had no idea were there. It's inevitable. You're going to find servers that maybe were abandoned, maybe someone left the company, and they were in charge of that server, and now it's there, and you didn't realize it until you did this data inventory. You're going to find all kinds of things. That's in fact, I think, based on my experience, for every 2 applications that were found, there was a third one that was not found until data inventory took place. So that's important. Create the DSAR process, or whatever we want to call it. That's going to take a lot of time. Get on it now. Also determine what goes into that report that you're going to share with someone and what form, whether it's going to be a PDF or it's going to be something that is copy and pasteable, if you will, or an Excel spreadsheet, but it's got to be something that's reasonably uniform and usable. Have a protocol to make sure nothing falls through the cracks, because I can tell you that calls to the AG's office are going to happen when companies don't get back to consumers, don't acknowledge them, don't give them an update of where they are with that. And then do update your privacy statement. That's been mentioned a couple times as well, but it's very important because people are going to go to the website and see what you have to say. So on that, and Katie, any additional items that you want to talk about before we start firing through questions here?
Yeah, I think just maybe one other item to point out. So I think where we struggle with data inventory is unstructured data. And I think even a tool like Experian is a really great way to tackle unstructured data. And what I tell my clients is if you run a tool across your full environment, your tool may be running for a long time. So when you do the data inventory and kind of step through, here is my key systems of record, a tool like Experian could be used to really tackle some of the more challenging data stores like unstructured data, SharePoint, shared drives, how you refer to those pockets of data where people just dump images, documents, and so on. So the way to solve unstructured data challenge could be also through running scans. But before you do that, do understand first what you have and do more of a manual survey-based approach, because then your scanning efforts could be more effective and efficient by understanding what you truly have.
Fabulous. Well, on that, then let's start zeroing in on some of these questions, and please feel free to jump in with me on these, Katie. Is there a clear definition of the various categories of personal data that you'll need to return to the customer? Yes, there is. That's the section that I did earlier. It's 1798, 140O as an Oscar. That has all of those fun categories. What impact will Shine the Light have? Will you have to name or itemize third-party providers? The short answer is that Shine the Light, which really requires companies to tell you what third parties have personal data that's for direct marketing. So you can think of Shine the Light as kind of a subset of CCPA. So will it impact it? No. Will you, the customer, or I'm sorry, you, the attendee here, be required to name or itemize those? Yes, absolutely, if it's for direct marketing purposes. What's the responsibility of an organization not located in California? It's the same as one that's located in California. It's all the same. It all depends on whether you meet that threshold, that doing business in, and then one of those three items that we mentioned earlier. What do the tea leaves say about AB 25? That is the proposed amendment to exempt employee data from the CCPA. Short answer is that there's no way to know. There's a lot of amendments that are before the Senate right now, the state Senate. I don't know if any of them are going to get through. We won't know until September, when the deadline is for all the Senate bills to be signed or vetoed. Katie, any comments about these? Yes.
Yeah, just to add on, I think this first bullet, what is personal information? We get it asked so much. We actually created a little cheat sheet for you, and we're happy to share it through this webinar on what the categories are and some definitions and examples. So I think this could be very valuable for some of you who are wondering what personal information is.
Wonderful. That's great. We'll definitely make sure that gets done then. Let's go to the next slide. So this one goes a little more in the weeds. If personal information is collected from a CRA, consumer reporting agency, for making a firm offer of credit, is that subject to the exception there? The short answer is arguably no. And that's because that information is really designed for generating a consumer report. It's a very narrow exception. So I don't see that as helping you, unfortunately. The next one is if you collect information from a consumer who provides an error, do you still have to account for that? Arguably, the answer is yes, because if you meet the other criteria, doing business in California, having one of those three sub-requirements met, yes, you have to do it. So that's why this is important. Even for those of you that don't, quote unquote, collect a lot of information, it's still important in case you get information accidentally. It's still now something that is part of your records system or system record, whatever you want to call it. The next one is 1798.100 grants consumers the right to request the business disclose specific pieces of information. Is that only apply if the consumer says, give me my specific pieces of information? I think the answer is no. That's a very narrow reading of this, expecting the consumer to say, please, Mr. and Ms. Business, give me my specific piece of information. I just don't see they're doing that. And really, it shouldn't be the consumer's job to read the law and understand it's that level of abstraction. So short answer is no, that's not going to be something that I would try to use. How do we avoid disclosing to someone who might not be the customer? That's a tough nut. And Katie, you've had experience with this, and certainly I did as well, with verifying who is someone, if they're really who they say they are, for GDPR. I don't know if you have any insight into this, if you've really had any opportunities to address that.
Yes, we have. So I think that's a very interesting question, and definitely one that comes up as an operational challenge. So the way that we've solved it, when you do a full analysis of everything you have, and when you create a form to allow a consumer to submit the request, we've seen where companies have been effective is designing the form based on the relationship of the consumer to the organization. So for example, an employee versus a customer, if you have a relationship as an employee, you submit that request and the request goes to HR. Most of the time, organizations have other personal information to be able to validate the identity of the individual. So if someone is submitting a request and they're saying they're employee or a past employee and you have no record of that, so you respond back to the individual to say that that relationship does not exist. So really trying to think about creative ways on how to identify consumers. And if a consumer is submitting a request by mistake or just assuming that they have a relationship, you should have a good, valid approach to respond to the consumer to let them know that you don't have any information on them. And oh, by the way, they have not entered into any sort of relationship with the organization.
Wonderful, wonderful, thank you. And then the last one here before we start taking things from the audience, a business must delete consumers' personal information that was collected from, and there's quotes here, from the consumer. Does that mean if information is collected from another source, it's not subject? Again, I think that's a very narrow reading of this. And while I appreciate the creativity here, I don't see this as a viable way. And you think about it, the idea is that the consumer could see data that's collected from another source, but they couldn't have it deleted somehow. I just don't see that. So unless your inside counsel really wants to go with that, and that's up to them, I would probably steer clear from that. It's just too easy to get this wrong.
Yeah, and I would agree with that, Scott. I think that question does come up for us as well. And the way that I approach it is if you're collecting information from a third party who collected information directly from the consumer, that obligation of disclosure is there. So to have an argument that you've collected it from a third party or purchased it from a third party will probably not stand in court if you have a significant breach or if you have inappropriately used the information of that consumer.
Wonderful, wonderful, wonderful. Let's do this. Let's take a couple more questions and then leave about a minute to do our wrap up, and that'll be it. So Abby, if you've got more questions in the queue, and by the way, whatever questions we didn't answer, they'll all go up on the blog. So no, we'll have that probably within a week from today. They'll be all up on the blog. So just to summarize here, and then we'll answer a couple more questions. This is the most demanding state privacy statute without a doubt. It just is. It's not unlike GDPR, and you're going to be involving all kinds of departments. It's going to be legal, marketing, HR, project management, not predicament management. Curse you, my spell checker. You're going to need guidance in a lot of areas. We just brought up some areas that are very, very narrow and focused in terms of the actual text of the law. And the penalties are going to be severe. I mean, this is going to be a big payday for the AG's office. This is where they make a lot of money. So keep that in mind as well. They're going to be looking for someone to make an example of. This is a part of a new generation of state privacy statutes. Katie mentioned that earlier. I'm going to do a webinar on that in about 2 weeks, in fact, on another 18 or so new privacy statutes that have been passed this year alone at the state level. So that tidal wave is continuing. So get started with data inventory. And as I said earlier, don't assume the legislature is going to come to the rescue. They created the situation. They're probably not going to help you get out of it. So we got 2 minutes left. Katie, do you want to take another 2 questions or so, and we'll close it up?
Yeah, let's do that. Sounds good.
Okay.
All right. If a consumer has debt with a business, but they request to be forgotten, does that business have the right to keep that data until the debt is paid off?
Yes, they do. Otherwise, that would be a really easy way to That would be a right to be out of debt, which does not exist in another law.
Okay. And would data on customers for the purpose of tracking visits to a store, something along the lines of a punch card, does that count towards the 50,000 record count since it's required to track value for a consumer?
Likely, because if you remember earlier discussion about interactions, you can make the argument that's an interaction with something that's a mechanism for advertising or something. Katie, what do you think?
Absolutely. Anytime I hear a word tracking or monitoring, it is definitely, in my mind, a higher risk, because once you start tracking visits and locations, it really becomes geolocation data. Is very important to address.
Wonderful. That's it, folks. I'm going to turn it back over to you, Abby. Katie, thank you for joining us. This has been just a wonderful hour. I can't believe it's gone by so fast. So thanks very much. And over to you, Abby.
Thank you. I just wanted to also say thank you, everyone, again for joining us today. A copy of the PowerPoint presentation, a link to the webinar recording will be provided in the coming days, as well as the document outlining the definitions of personal data that Katie mentioned. Thank you to Scott and Katie for an excellent presentation today. We really appreciate it. And as Scott mentioned, we hope to see you at our next webinar on Wednesday, July 10th, covering how U.S. states are leading the way on privacy in 2019. A registration link will be on Spirion.com shortly, as well as the blog with all of the questions that were submitted today. Thanks again and have a great day, everyone.